Assalamualaikum warahmatullahi wabarakatuh. So this is part two, second part for the Zoom recorded lecture for the topic capacity to contract, and the focus is on minus contract. In the first part, we covered the rule, basically the general rule, as well as position in Malaysia and some cases, including Mohori Bibi, as well as cases from Malaysia, okay, Malaysian case or local case. So for part two now, we want to focus on the position at common law or under English law. And then we are going to discuss on what amounts to necessaries, the rule which relates to necessaries. Okay, as compared to position in Malaysia, okay, or whatever, or the rule which we extract from the case of Mohari Bibi, in which it says that whatever contract entered into by minor is void. But in comparison to common law, English law, so over there, so a contract entered into by a minor in England, okay, is either valid or voidable. So meaning the rule doesn't start with void, but it starts with valid. But then again, valid here for what? Okay, it has specific circumstances in which the contract will be valid. So basically, if the subject matter of the contract is necessaries, then the contract is valid. And if they are not necessaries, so the contract is not void, okay, at common law or under English law. The law treats the contract as voidable. It is possible to validate the contract, to make it valid. At whose option? Okay, who has the right to make it valid or not here? At the minor's option. So the approach here is different or slightly different compared to position. Compared to the rule that we extract from Mohari Bibi as well as position in Malaysia. Okay, we go to what are the rule which relates to necessaries. So supply of necessaries. So we want to know what's the meaning of necessaries, because why? A minor is bound to pay for necessaries. This is the rule at common law. Okay, a minor is bound to pay for necessaries supplied to him under the contract. So impliedly in the here the contract is valid, because why? The minor is, it can be made it can be made binding on the minor, okay, because minor is bound to pay, he has to pay legally. The contract is enforceable. So now we want to know what's the meaning, okay, of the word necessaries here. What is the interpretation of the word? So when we talk about necessaries, okay, necessaries here, they refer to those things without which a person cannot reasonably exist. So it must be there for a person, a reasonable person, to exist. And it will include food, clothing, lodging, accommodation, education or training in the trade, and essential services. So it's quite broad here. Okay, it covers all kinds of food, clothing, lodging, education, and training. So all these things are necessaries, the things which are necessary for a human being to exist reasonably. Okay, and then the further elaboration of the word necessaries here. So it will depend on the condition of the life of the minor. Okay, what does it mean here? It means it refers to social status and the minor's wealth. Okay, because why? What is regarded as necessary for the minor, okay, residing in a stately home, in a very big home, it mentioned, okay, may be unnecessary for the resident of a council flat, the lower part of the society. Okay, because even in Malaysia we have the categories like T20, okay, M40 and B40. Okay, so when we talk about necessaries here, so the one which is regarded as necessary for those minor, okay, residing in a huge home will be different compared to the one residing in a low cost flat, for example. So whatever the minor status, so the goods here, necessaries here, must be suitable, okay, to his actual requirements. For example, if the minor already has enough fancy waistcoat, okay, enough fancy clothing, so more cannot be necessary. If he go and buy for more fancy waistcoat, fancy clothing, then it doesn't amount to necessary in that particular situation. Let's have a look at the case law, common law. The case of Nash and Inman, very old case, 1908, and decided by Court of Appeal. So this is a suit between a tailor, okay, who sued a minor. The minor was the customer, okay? And actually this tailor had supplied clothes, okay? And it includes 11 fancy waistcoats. So what's the observation by the court? Okay, the court decided that, yes, the minor was an undergraduate at Cambridge University, prestigious university at the time, okay? So whether these clothes are necessaries, yes, okay, the clothes were suitable according to the minor's station in life. So as an undergraduate at such reputable university, so all those clothes are necessaries. But actually, as far as the case was concerned, the tailor cannot, the further finding by the court was that, okay, the retailer cannot claim because the minor already had sufficient clothing. So whatever that he bought or whatever being supplied by the tailor here is no longer a necessary. I mean, it's beyond necessary. So there must be a certain number of clothing that you require as necessary. And if you order for more, if you buy for more, then it doesn't amount to necessary. It's not regarded as necessary anymore. So generally it is necessary, but then after at some stage, it's no longer considered as necessary. So that's what the finding or the observation by the court in the case of Nash and Hinman. Okay, what's the position in Malaysia? Do we have any specific rule pertaining to necessaries? Actually, we have. Okay, we can see the word. The word necessaries is clearly mentioned in under section 69 Contract Act 1950. Okay. So under this particular section, it provides, okay, for reimbursement for necessaries. It doesn't say the contract is valid or avoidable, but this section allows for reimbursement on the other party. Okay, meaning here the party, the major entered into contract with the minor to supply necessaries. Then actually the other contracting party who contracted with the minor can get the reimbursement. Okay, notwithstanding the fact that a contract entered into by minors for necessaries are but meaning here it doesn't change the legal status of the contract, but the law allows for reimbursement. Because why? Because the things which were provided or which were given to the minor was necessaries. If it's not necessaries, then no reimbursement whatsoever. Cannot ask for payment. And this is I just reproduced the whole provision here, okay, the actual wordings. So if a person incapable of entering into a contract, so or anyone who is legally bound to support is supplied by another person with necessaries. So take note of the word, okay, I put in a red font, suited to his condition in life, okay, the person who has furnished such supplies is entitled, legally entitled to be reimbursed, can get a payment from the property of such incapable person. And the section provides two illustration, but it is the example relates to mentally disordered person, but actually it is equally similar. The effect will be similar to the one to the minor. Okay, meaning here lacks of capacity. Example illustration A here, A supplies B. Meaning B here is is a person with lacks capacity to enter into contract. B, a mentally disordered person, okay, with necessaries suitable to his condition, to B's condition in life. So whether A can get the payment here, yes, A is entitled to be reimbursed from B's property. Okay, and then second example also relates to mentally disordered. A supplies the wife and children of B, okay, a mentally disordered person with necessaries suitable to their condition in life. So again, A, the one who supplied the necessaries here, A is entitled to be reimbursed from B's property. So in this situation, these two situations, minors or even mentally disordered person here cannot run away from payment. Must pay. Okay, or the term used is reimbursement, to be reimbursed. Okay, let's have a look at the case law, which relates to necessaries. The case is Government of Malaysia and Gucharan Singh and others, 1978. Okay, this is the suit by Government of Malaysia. So they sued two defendants. Okay, first defendant as the promisor and three defendants altogether. Second and third defendants as sureties, the guarantor. Okay, for breach of an agreement in writing. And actually these parties, both plaintiff defendant, they entered into a contract for providing a course of training at Malayan teachers training. So to provide for teachers training to become a teacher. And the value of the actually this is in a form of scholarship actually, okay? Because I mean here the trainee received scholarship from government, right? So 5 years after the training. Meaning that here you must serve as a teacher for 5 years after the training, and the amount was 11,500. This is the actual amount spent by the government. Okay, what's the purpose? On educating the first defendant, the scholarship holder, okay, as provided in the agreement, covers interest and costs. And then in relation to our discussion here, okay, the defense was essentially that the contract, this is the defense by the defendant, okay, meaning that here, oh, we don't want to pay. Because why? We are not bound by the agreement. Because why? The contract entered into by the first defendant was void because when he signed the agreement, he was a minor, okay. He didn't reach yet to reach the age of 18. And then because of that, okay, all the sureties, guarantors are also not liable because the contract was void. And then as far on the part of government, actually a government was claiming for repayment of the sum, okay, which was spent, okay. And then the claim was that, well, all this sum, okay, expenses here actually it amounted to necessary. So that's why the government should be reimbursed. And then the lawyer, okay, this is the defense, okay, by the defense counsel, the argument on the part of the defendant. Okay, the argument was that, well, necessaries in section 69 here, okay, it doesn't provide for the interpretation. So it only covered, okay, goods, articles, and other services, but it doesn't cover education, okay, and instruction. And of course, it doesn't cover the training to be a teacher. So basically, section 69 is not relevant. So there's no reimbursement whatsoever. So this is the defense put forward by the counsel representing the defendants. And this is the relevant part of our discussion, because why? The court provides for interpretation in its observation or its decision. Okay, the court observed that the word necessaries here must be construed, must be interpreted broadly, and in any decision involving, okay, whether what are supplied are or are not necessaries. So it is incumbent, okay, it must, okay, or it is inevitable to have regard to the facts of the case, and the court will look at the conditions and circumstances, okay, and the purpose, okay, for which the money was spent, okay, according to the agreement. So what was the finding by the court? So in the court's view, okay, the circumstances of this case, so the act of providing, okay, the provision of professional or vocational training for the first defendant in a teacher's training institution to enable him, okay, for his future, for his life, to enable him to qualify for and accept the appointment as a teacher is actually, it amounts to necessaries. It's a provision for necessaries. So because of that, first defendant, okay, is liable for the repayment of the sums expended, okay, on his education and training. Because why? This is the expenses, okay, being expended on necessaries. So meaning that here the court rejected the counsel's argument, the defendant's counsel argument. And because of this case as well, there was amendment to the Contracts Act. So as a result of the above case, the case of, what's the case name again? The case Government of Malaysia and Gocharan Singh. Okay, so the legislature, Parliament, passed Contracts Amendment Act 1976. Okay, so by virtue of the amendment, it provides for Section 4, Clause A. Okay, and you can read the provision later at the back of your Contracts Act. Okay, that notwithstanding anything to the contrary contained in the Contracts Act, okay, it applies specifically to this scholarship agreement entered into by a minor. So basically, it is valid. So the minor is not allowed to plead minority. Whenever it involves scholarship agreement, the contract will be valid. Okay, that's the provision under Section 4A. Okay, we stop here. We are going to continue in the next part to cover marriage contract. So I stop sharing first. Okay, Assalamualaikum warahmatullahi wabarakatuh.